interrupt our regularly scheduled program to bring you this breaking news alert.
And you're taking a live look down the hallway now as we understand the family members of some of the children killed have just walked into the courtroom. I just saw Craig Schilling, the father of Justin Schilling. Saw Nicole Beausoleil, the mother of Madison Baldwin, and the jury has reached a verdict. This has been 10 hours from yesterday and today that they have been deliberating. We understand that the jury does have a verdict. They're going to be reading that shortly. They're not really waiting on anything other than for counsel to get into the courtroom. We should be having a live look inside the courtroom right now. My colleague Sarah Michaels is in there, and she's going to be texting us updates. But I mean, this has been a very long day for a lot of folks out here. But everybody really just stressing that they just want this jury to take their time and to come up with a decision that so many people believe will be guilty for James Crumbley. You guys?
All right, Kim, thank you so much. And we know we've been hearing from families, of course, waiting bated breath to see what this verdict is. And many of them saying, this was a team. We just heard a family member say this was not just one parent or the other. This was a parenting team. Even within those notes from Ethan Crumbley saying, my parents, nobody's listening to me. He wrote about it. So we bring in our chief investigator, Heather Catallo. Heather, you've been watching this closely, following along. Where do we think the jury is as we have a verdict?
I mean, they've been going 10 hours today alone. They deliberated a little bit yesterday. This case came in a little bit more quickly than Jennifer Crumbley's case did. It felt a lot faster to a lot of people. The prosecutor kept commenting in the court where this is moving along quite a bit. But they've been talking and discussing amongst themselves all day today. You can never fully predict what the jury is going to do. They've had a lot of things to look at and a lot of things to discuss, and we're about to find out. But as you've said, the families have been demanding accountability since 2021. So they got the conviction with the mother. Obviously, the son pleaded guilty. We will see what the jury decided here.
Yes.
And of course, the parents of the victims are hoping for that guilty verdict. But let's talk a little bit about the difference kind of between these two trials. It's my understanding that with James Crumbley, they really focused on the purchase of that gun, any sort of kind of involvement around that gun and the safe storage of it. What have you noticed?
That was the key, and if you recall, someone from the jury, when they spoke to the media after the last verdict, they did point out that one of the key factors was seeing Jennifer Crumbley was the last person they saw with the gun. Now, knowing that James made the purchase, that could be a really key factor here.
And when you speak about the difference in these cases, and as you touched on, Mike, the focus being on storage and attention and those kinds of things, there was a key focus to the extramarital affair that Jennifer Crumbley was involved in.
That was in her case, then.
And yes, and the attention paid there. So when we talk about the differences of focus, but both equaling the fact that the attention wasn't where it should have been.
But this was different in that they didn't have as many text messages between father and son as they did with mother and son.
Yes.
So it'll be interesting to see if that changes how the jury looked at the information.
Now, for those of you just joining us, a verdict has been reached in James Crumbley's trial. I did want to ask you, Heather, when it comes to James, we're going to be talking about the fact that he chose not to take the stand, whereas Jennifer did. What do you make of that? Do you think that worked to his advantage?
We'll have to see what the jury decides. I mean, legal experts will tell you, obviously, it's not very common that defendants do that. Obviously, Jennifer did. So I think a lot of lawyers and people that are really experienced with the court system did not feel like that served her well. He had the advantage of that they saw that play out, so they made a different choice. But maybe the jury wanted to hear from him. So obviously, he does not have to. He's not required to do that, and they're told that. But we'll see what they say.
Heather, thank you. Thank you for being with us. Please don't go. We appreciate your expertise, but we do have on hold, on the phone, who's been following this case closely and with us here at Channel 7, always a legal expert that we turn to and count on. Todd Flood with us on the phone this afternoon. And Todd, we understand that the jury has come back and may have a verdict right now.
Yeah, I believe they do actually have a verdict right now. So we'll see what happens. They had a long day. They started at least at 9 o'clock, and now it's 7 o'clock. So they've been going at it for a while. And we'll see one way or the other. I mean, at the end of all of this, I think the elements were met by the prosecution, by the government, but you never know.
Now, Todd, you've been involved in many, many trials. We have this time frame right now of about 10 hours today, a very short time yesterday. What does this indicate to you?
There was fighters for one side or the other that pushed back on the verdict, wanting to know, wanted questions answered for whatever side it was. I think they got hung up a little bit on the counselor. They obviously had some issues. They wanted to see that testimony again. I believe that that had an impact. But being out this long on one particular day is, I think, very stressful. It's also stressful on a jury. It means to me the bottom line is there was someone fighting to get answers on questions they wanted to come to the verdict, either that of proof beyond a reasonable doubt or, for the defense and showing reasonable doubt.
Todd, are you able to please walk us through some of the elements that we could see focused on for a conviction?
So I think the big one here is the duty and the foreseeability. It's a failure to act. So the parent has a duty. There's two theories that they can use in this case: the gross negligence that he bought the gun and didn't take any ordinary care that a parent should have, and saw that drawing. That's one theory. The other theory, the failure to act of not preventing this, and it was reasonably foreseeable. So you think about it. One theory basically is that of, hey, you needed to secure this gun. You didn't do that. I think Karen McDonald did an excellent job of displaying, of putting a lock within it, and took 10 seconds. You failed to do that, which is just ordinary care. The other theory that the government put forth was, listen, he was there at the principal's office, and the father knew there was a gun that his son had. And what did he do after he heard about the shooting? He goes home ultimately to search to see if his son had the gun. That's called foreseeability. So the elements here of duty and ordinary care and foreseeability, I think, are the big pieces to the puzzle for which the government had to show. And at least from my standpoint, and I could be wrong, obviously, here, because the jury's going to make the determination, it seemed as though the prosecution met those elements.
Okay, Todd, thank you so much for weighing in on this. Now, the jury has entered court. We're going to take that live if we can. Let's listen in now to what's going on.
All rise. Court is now in session. The Honorable Cheryl Lee Matthews presiding.
Good evening. You may be seated.
Your Honor, calling People v. James Crumbley, case number 22279-989-FH.
Thank you, Mark Keith, on behalf of People.
Karen McDonald on behalf of People. Good evening, Your Honor. Mario Lamina on behalf of James Crumbley.
Mr. Crumbley, can you hear us?
Yes, I can. Thank you.
All right, you can be seated. I want to indicate, first of all, there was a question the media was dying to know about. I'm going to read that into the record. I consulted with the attorneys who answered the question, and so then I sent the question back in. They agreed on the answer. The jury asked, please define Article 16.13, bullet number 4, define willfully neglected and grossly negligent. The lawyers agreed to answer the question, please see jury instruction 16.18 for the definition of gross negligence. All other definitions are contained within jury instruction 16.13. I also want to point out that there's a request by the media to ask the jury members if they would be willing to remain in the courthouse and be questioned off camera. Because there would be a verdict and no other defendant pending trial, I would have been willing to do that. But the courthouse closes at 4:30, and I have continually imposed on the courthouse for the sake of this trial and the other one. I cannot impose on the staff or the deputies any further. I also want to indicate that with regard to case number 22-279990 FH, the People versus Jennifer Crumbley, there is an order restricting pretrial publicity. It was entered on July 14th, 2022. That order will be set aside as soon as the verdict is read. I will also be issuing an order that will obviously not be made public in the courthouse until tomorrow morning. In addition, case number 22-279989 FH, the People versus James Crumbley, the same thing. The order restricting pretrial publicity was entered on July 14th, 2022, and that order will also be set aside as of the reading of the verdict. Are you ready for the jury?
Yes, Your Honor.
Yes, Your Honor. All rise to the jury.
Good evening. You may be seated. Ladies and gentlemen, I know you've worked very hard. We've all been awaiting your decision. I know this was a very intense decision for you all to make. I believe you've selected a foreperson. Who's the foreperson? You're the foreperson. Could you read the verdict, please?
Each count?
Sure.
Count 1, involuntary manslaughter as to Madison Baldwin. Guilty of involuntary manslaughter as to Madison Baldwin. Count 2, involuntary manslaughter as to Tate Meir. Guilty of involuntary manslaughter as to Tate Meir. Count 3, involuntary manslaughter as to Hannah St. Juliana. Guilty of involuntary manslaughter as to Hannah St. Juliana. Count 4, involuntary manslaughter as to Justin Schilling. Guilty of involuntary manslaughter as to Justin Schilling.
Thank you, foreperson. I'm going to ask that Ms. Williams pull the jury. So she's going to ask you each.
Jury in seat number 1, was that and is that your verdict?
It is.
Jury in seat number 2, was that and is that your verdict?
It is.
Jury in seat number 3, was that and is that your verdict?
It is.
Jury in seat number 4, was that and is that your verdict?
It is.
Jury in seat number 6, was that and is that your verdict?
It is.
Jury in seat number 7, was that and is that your verdict?
It is.
Jury in seat number 8, was that and is that your verdict?
It is.
Jury in seat number 9, was that and is that your verdict?
It is.
Jury in seat number 11, was that and is that your verdict?
It is.
Jury in seat number 12, was that and is that your verdict?
Yes, it is.
Jury in seat number 13, was that and is that your verdict?
It is.
Jury in seat number 14, was that and is that your verdict?
It is.
Thank you, ladies and gentlemen. I know how hard this has been on all of you just by reading your face. I know this has been a very hard decision. We appreciate your time. I'm going to ask you to return to the jury room, and I'll be there with you in a few minutes, all right?
All rise for the jury.
The verdict is in. We heard guilty on all 4 counts of involuntary manslaughter. We were able to see some of the reaction in the courtroom from some of the family members. We saw tears almost immediately. We have now with us on Zoom former Chief Judge of Wayne County, Judge Kenny. Can you hear us, Judge? Are you with us?
Yes, I can hear you.
Does this surprise you, this guilty verdict on all 4 counts?
No, it does not. I think that the prosecution put in a very strong case. While this case was tried very differently by the defense, I think that the volume of the evidence certainly was sufficient for the guilty verdict in this particular case. Specifically, I thought there were 3 things that really made the case for the prosecution. I thought they had a compelling way of finishing up their case. The next to the last witness was a witness that showed the video of the actual shooting within the school, which is just horrifying evidence and very, very strong and compelling. And that was followed then by the officer in charge, who was reading the notes from the shooter's journal. And those 2 things together at the end of the prosecution's case, I thought was very compelling evidence.
Judge Kinney, now we didn't get many questions from the jury the entire time that they were debating right there, but we did hear that they asked a question about the definition of gross negligence. What do you make of that question?
Well, I think gross negligence was one of the key elements that the prosecution had to prove. As we all know, this was not a case of simply was there bad parenting. This was a case where there had to be a showing of what the law requires as gross negligence. And I think the jury wanted to be clear as to exactly what that definition was.
Well, Judge, if you don't mind hanging with us, sir, we'd appreciate that. We're going to go now outside of the courtroom to Sarah Michaels. Sarah, if you're with us, we know you spoke with family members as this was happening. Fill us in.
Family members really tonight.
Yeah.
Lester?
Yeah, Glenda, we were able to speak to multiple family members who were here outside the courtroom with us today, and I asked them, what is some of the evidence that was the most compelling to them during James's trial? And I was told that 911 phone call from James Crumbley, within minutes when he heard about the Oxford High School shooting, he called 911 and said that he was going home to check and see where the firearm was that he gave to his son, the shooter. And the parents told me that was so compelling because when they heard about the shooting, it never crossed their mind that their child might be the shooter and that one of their firearms might be missing. To turn our attention right now, we're seeing some people exiting the courtroom. It appears that some of those family members have gone the other way. While we wait for them right now, I'll talk to you about some other conversations we had with those parents just as we were waiting for this verdict. Craig Schilling, the father of Justin Schilling, he told us that today for him is all about accountability. He has been here for every single trial, the trial of the shooter who was found guilty, the trial of Jennifer Crumbley last month who was found guilty. He said today, James Crumbley being found guilty, this to him was the final piece to the puzzle. This is something that brings a lot of peace to them. Yesterday, the mother of Madison Baldwin telling our team that every single time these parents have to go through one of these trials, they have to relive this case and they see new pieces of evidence and they are triggered in different ways. So by finishing this today, this is going to be able to hopefully bring a sense of peace to these families who have just been through so much and they have to relive this every single time. As you know, the jury deliberated for over 8 hours today, and the attorney for the families telling us that the families were glad that the jury took its time to deliberate because there's no downplaying how historic of a trial this is. With this verdict, James Crumbley is now the second parent ever in United States history, the first being his wife Jennifer Crumbley, to be found guilty of involuntary manslaughter for the crimes of their child. I was able to ask some of the parents of some of the victims of the Oxford High School shooting today, what does it mean to them? You know, a lot of times when we have these tragic events, people say thoughts and prayers, and we hear from other people that that's not enough. Well, the parents of some of the victims told me that this to them is a step forward. It's a monumental day here, a historic day in Michigan. We're going to stay live outside and see if we can hear from any of those family members once again. For now, I'm going to toss it back to you guys in the studio.
Okay, Sarah, we sure do appreciate you staying on top of this all day long. Now, if you're just joining us, James Crumbley found guilty of 4 counts of involuntary manslaughter, 1 for each of the victims killed in the Oxford High School shooting. We heard from a lot of these families saying that they just wanted to see almost a clean sweep, a guilty on each person that was involved in this shooting, and hopefully they
needed that.
Yes.
A lot of them said they needed that.
They definitely did. They've been sitting there, and this has just been absolute torture for them, but they felt like they needed to be there for their children, and they've sat there and they've watched all of this come in. They've watched that horrific video over and over again, but as you said, a historic decision. Second parent guilty, involuntary manslaughter in a mass shooting. The courts have held parents responsible for the actions of their children before, but this is in reference to a mass school shooting. Historic.
Important distinction, because we do see the difference.
And there's been a lot of talk about the fact that this has been unprecedented, and so people want to know, like, will this hold up on appeal? That's the next question that a lot of people have. Let's go to attorney Todd Flood for some input on that. Todd, when it comes to an instance like this, is it as unprecedented as some people think, or is this comparable to, let's say, a firearm found in a home and that caused an incident?
It's comparable. This case has been prosecuted on individual basis for parents being grossly negligent of leaving the gun out. We've seen it all around the country. We just saw recently one down south where a child brought a gun in and shot the teacher. The parent was prosecuted for that case. It happens. This is the first time in our country we've had a parent held accountable for a mass shooting where their son or daughter, and obviously here the shooter taking the lives and also wounding several others. So, yes, it's unprecedented from that standpoint, but no, not unprecedented from the standpoint we've held parents accountable for their acts of children when they've been grossly negligent.
And Todd, you've been with us throughout this entire time in this course of all 3 of these individuals facing charges. When you look at the evidence in terms of, did they pay attention? Were they there? Were they listening to their child? That could make the difference in setting the precedent for the future in how these charges play out.
Well, I think Judge Kennedy put it concisely and perfect. This isn't prosecuting bad parents. This is prosecuting parents that were grossly negligent, that didn't give, just a modicum of care, the ordinary care that a reasonable person would give. And that, I think, is really the point. This, when you look at their acts, as we've pointed out a few times, one of the jurors apparently just said, that Mr. Crumbley here, his first move was to find out if the gun that he bought for the shooter was there in the house. That shows the foreseeability. I think instead of putting your arms around your child when you're in the principal's office and you see that demonic picture that he draws, and you know that you bought him a gun, but you don't put your arms around the kid to say, hey, listen, what's going on here, and you leave. That to me is disturbing, because that's not a reasonable act. That's not ordinary care. So I think people should understand that this I hope, and I really believe, and I look at Judge Kennedy for his opinion, but I don't think this is a slippery slope of multiple charges coming down. I just think this was a definition of gross negligence. I thought the defense did a great job with what she had, but it was overwhelming. And just keep on going back from that day of the incident and backwards and see how many red lights both parents went through, the alarms and the sirens of what do you have to do to prevent this is just, 1, secure your gun, 2, put in a proper lock, 3, when your child writes such demonic messages, maybe do something because you know other people could be injured. Those are thoughts that it's too big of a mountain to overcome.
Todd, just one more question for you real quick. I wanted to ask you about that defense. Now, we heard from James Crumbley's defense attorney in closing arguments that he had no idea his son was having a hard time, that James didn't know anything about his son's journal. Was there any piece of evidence that you thought contradicted that really stood out?
Yeah. Well, when he leaves, he also says with forked tongue, yeah, I'm here to talk with you. There's counselors here to talk with you. So if he really believed that his son was either self-injurious or injurious to others, why is it that he's saying, we can get you counseling? That doesn't make sense. So if you juxtapose those two thoughts, I just don't think it washes.
Todd, thank you. We're going to go to Judge Kenney for a second as he waits there to listen in. And Judge Kenney, can you comment to that, the gross negligence and what this sets up for the future, the precedents that this case sets?
Certainly. I know that there have been a number of people who have said that this ought to alarm parents, that this could happen to anyone. And I don't think that's the case. When you look at a case such as this, where there is a requirement that the prosecutor prove beyond a reasonable doubt that there was gross negligence, you look at the cumulative effect of all of these facts that were presented during this trial. This clearly, in my view, showed that there was gross negligence. When you look at the fact that in the journal, the shooter mentions how he's repeatedly reached out to his parents saying he wants help, he's terribly depressed, and that he wants a therapist, and his parents just refused to let him get help. And then in light of what happened on the day of the shooting, when the parents receive an emergency call to come to the school, and they end up staying there for 11 or 12 minutes, and then they leave after seeing what he had written on the math page to go home and do DoorDash deliveries as opposed to getting the mental health services and care that their son needs. That is pretty powerful evidence, I think, of gross negligence. And then I think the final piece was when you look at the search warrant that took place at the home, to say that the ammunition was hidden under a pair of jeans, no cable lock for the gun, no gun lock at all. This was no effort whatsoever, I think, for any reasonable person to believe that James Crumbley was securing this weapon, and particularly securing a weapon away from his very troubled son.
Judge Kenney, thank you so much, sir. We really appreciate that take. Kimberly Craig, outside of the courthouse. Kim, fill us in on where you are.
Glenda, we just heard from the prosecutor's office as Karen McDonald was actually walking past a lot of us reporters in the hallway. We were hoping to talk to her out here, but we just got word that they're going to have a press conference in the prosecutor's office in about 25 to 30 minutes. But after the verdict was read and after they released the jury, you could see the emotion on the families' faces. as they hugged the prosecutor's office, members of the prosecutor's office, particularly Karen McDonald. This has been a very difficult, obviously, not on top of the tragedy of losing their loved ones, losing their children. They've had to go through this now, not just during the Miller hearing, and hear and see some of the horrific things of the last moments of their children's lives. And they've had to go through it again when Jennifer Crumbley was on trial. She was found guilty on all 4 counts, and now James Crumbley, they had to go through that again. And you can only imagine just how taxing, but yet this is the moment that they have waited for. Like some of the parents were telling us earlier today, this is another step in the accountability. First it was a shooter, then it was the shooter's mother, now it's the shooter's father, and now they want the school to be held accountable. Back to you.
Okay, Kim, and we know you've been out there all day following this very closely. So perhaps this is justice served for the families of Tate Meir, Madison Baldwin, Hannah St. Juliana, and Justin Schilling. Heather, you've also been following this every step of the way. Is this something that you expected, and what do you think it happens going forward?
Well, I think that as we've been watching the evidence come in, I think that many people were somewhat predicting this outcome. Obviously, you can never tell with the jury. You can never tell exactly what's going to resonate with them. But as Kim was saying, this is a step in the process for accountability for the families. There is still one more step, that is the school district. And so we'll have to see what happens going forward. I believe the prosecutor has said in the past that there are no more criminal charges coming, but there is still the civil litigation coming. And if Kim is still with us, I would love to be able to talk to her, because one of the things that's really key, as you know, when we cover trials, when you are in the courtroom, when you're, whether it's the attorneys or the people sitting there, you can see the jury. When we're watching it on the feed coming in, we're just seeing the witness and the exchanges with the attorneys and the judge. We don't get to see the jury's reaction. So it's always a different feel when you're in there. And I know one of the things from talking to Kim during the last trial and talking to Simon Shaquette during this trial, when those video elements were introduced, especially the video of the shooter at the range firing the murder weapon.
Yes.
That video, I'm told, the jurors reacted strongly to. And I'd love to hear Kim's take, because she's been there in the courtroom and she was able to observe what some of the jurors were really responding to. Kim?
Yeah, well, so Simon was actually in the courtroom when the jury was watching the surveillance video of the shooter going through the school, and that was probably some of the most traumatizing video that anybody has ever had to see. But watching them also at the range, Ethan Crumbley, I mean, he, just like one of the special agents testified, he operated with that firearm like he was a professional. Like he had professional, I should maybe not say professional training, because that can get a little tricky there, but he had some training. It was clear that he had some training. On the video as well, I did see it during Jennifer Crumbley's trial, he was very calculated in how he walked about that school. The special agent and the other investigators testified as to how he took a stance where you knew he had some sort of training. And so it's really hard to imagine. James Crumbley, he knows his son is having issues. Even if it was just the day of the shooting, hours before, 3 hours before the shooting, he sees that math worksheet and can see what his son has written. If he had no knowledge of anything even prior to that, that worksheet should have woke him up. But it didn't. He went back to door dashing and his wife went back to work, and they were just going to deal with it later. How do you see your child writing blood everywhere and all the other things that were written on that worksheet and think that you have some time to address it other than right there, right then? At least at that moment, go home and check for the guns. Don't wait 2 hours until you get a notification from the school that there's an active shooter. Back to you.
Yes.
As the prosecutor said in her closing, how many times did he have to say, "Help me"?
Yes.
She made that point several times. He wrote it on the worksheet. How many times did he have to say, "Help me," for someone to offer help?
And to your point, Heather, we did not see the jury's faces as the verdicts were being read, but we heard each and every one of them said, yes, I stand by that. Yes, that is also my vote. So.
And now they have spoken.
They have.
Well, at the heart of this case, those 4 young lives lost at Oxford High School. Tate Muir, 16 years old, the beloved football star who made the varsity team as a freshman. He also was an honor roll student and just an all-around kind young man.
Madison Baldwin, 17 years old, remembered as a beautiful, bright, sweet girl, an artist who loved to draw, to read, and to write. She was due to graduate and looking forward to college.
Hannah St. Juliana, 14 years old, basketball player, remembered for her kind heart, silly personality, and just her passion for the game. She was about to make her debut with the Oxford team.
And Justin Schilling, 17 years old, a scholar and lettered athlete who relatives say had unlimited potential. Those who knew him say Justin was simply just a pleasure to be around.
4 lives all gone too soon. 4 lives that will never be forgotten. 4 lives taken in place where everybody hoped they'd be safe.
And stay with 7 Action News and WXYZ for continuing coverage of the verdict and the sentencing. We'll update you on air and online as this story unfolds.